with offices in Nutley, Montclair, New Jersey. Today is my weekly how-to series where I take a what I call medium-sized topic as opposed to my daily tips, which are small topics, and I give you a few minutes of advice how to handle them, a little more in depth than my daily topics and a lot less in depth than my monthly webinars. But usually the topic doesn't require that. Before I go into it, also like to remind everybody that I am doing this on April 4th, 2019. So if you're watching this at any other time, you have to check to make sure the laws still apply. And I'm doing this in New Jersey. I'm only referring to New Jersey law, so you have to make sure that that applies because you may be in a different jurisdiction. So with that, let's jump into how to modify or terminate alimony. And the first thing to tell you before I go into the reasons for it and how to do it is to realize also that modification and termination are two things, but you should always be asking for that. And in some strange cases, which I won't go into the reasons why, you have to ask for modification to zero, which is technically not a termination because there may be an alimony obligation that cannot be terminated because each type of alimony has a different modification ground. And if you cannot terminate the duration, you can eliminate the dollar amount, and that will end the obligation, but it's technically a modification. So first, let me just talk briefly about the types of alimony and the reason, or what the underlying basis for modification would be. So first, you have open durational alimony, which can be really modified for any of the reasons that I'm going to speak about in a moment with no great limitations. There's reimbursement alimony, which is for the compensation of a spouse that helped another spouse obtain either a valuable learning degree or some other valuable asset. It's not in the nature of alimony, but there still is a repayment obligation. They call it alimony because there's no other way to do it. That too can be modified without any restrictions into what I'm about to mention. There's reimbursement alimony that can have some limitations. I'm sorry, not reimbursement alimony. I just did that. Rehabilitation alimony. Rehabilitation alimony is used to help a spouse who is economically disadvantaged during a relationship sort of get back on his or her feet. So that can be extended or modified if the issues that were anticipated do not occur, like the spouse was supposed to get education or work experience, and that did not occur. It can be extended. So the reasons for modification I'm going to talk about do equally apply, but you should know that that can also be extended. And then lastly, there's limited duration alimony, which is alimony for a specific period of time. That can be amended in the ways that I'm going to talk about, but the unique issue to limited duration, which is probably the most common that we see, is that you can modify the amount, you cannot modify the duration. So just as I mentioned when I opened up that in certain cases you want to modify to zero instead of terminating, limited duration alimony would be one of the types of alimony, if you have it, that you might actually be looking for that kind of unique adjustment. So that being said, that's the basic types of alimony and the basic reasons or prohibitions against modification. Now let's talk about the things that you'll need to know in order to do so. First, you're going to need to know the reasons why, and then you're going to need to know the steps how to do it. So first, the reasons, I'm going to go through them quickly, briefly, and then talk about them a little bit individually. First is based on whatever the agreement that you entered or your court order says. Most alimony obligations are reached by an agreement between the two parties, and they may have specific reasons or prohibitions for and against modification and termination. So you'd first turn to that agreement or the court order, but usually court orders don't have many restrictions or even contemplate modification terms. Then there's remarriage, there's cohabitation, sorry, long week, actual and prospective retirement, and a material and substantial change of circumstances. Now, remarriage should be obvious. That would also apply for civil unions and domestic partnerships. Cohabitation, got it right this time, is a unique and troublesome case in that first it's difficult to prove. But the new, I always say new, but the recent amendments from 2014 allow you to modify or terminate cohabitation if you prove cohabitation, but the other party can return if that cohabitation ends, which is problematic because it gives them the option of trying it, and if they lose, of just kicking the person out of the house and going back for alimony. Then there's actual and prospective retirement. This was also part of the 2014 amendments. What they did was actually really helpful because they added the prospective retirement. And what used to happen was if you had an alimony obligation and you were about to retire, you couldn't retire because you needed to make sure that you were going to modify or terminate your alimony, but you couldn't modify or terminate your alimony until you actually retired. So a lot of people would file and say, I'd like to retire, and the courts would say there's no change of circumstances and deny it. Now they've retired, they lost their job, but also have their alimony obligation intact. Or people would say, I want to retire, but I need to end my alimony, and they would say, well, you can't ask us because nothing has changed yet. You have to first retire. So it was a horrible catch-22. People were caught in. They remedied that with the 2014 amendment. So now you can prospectively retire. It is presumed under the statute if you reach retirement age for your profession, which generally is going to be 65, it's presumed to be a good faith retirement, and it's the other party's obligation to show why that could not be the case. There are some cases where retirement much earlier can be appropriate. The common example I use would be police and firemen who may go on the force at their late 20s and be on for 2025 and come out in their late 40s and retire. And that may be appropriate in some cases, and it may not be, but that's why we have the new amendment and the statutes to determine what you need to do. I'm not going to go into the specifics for retirement modification issues because they're very complex and they're not really a topic for this series, but I think I did do 2 webinars on the 2014 amendments and alimony in New Jersey. So in those webinars, I would have gone into much greater detail about things like retirement. And then the last one is a material and substantial change of circumstances, which is hard to discuss in a video, especially one as short as this, because there's no clear definition to what that could be. Obviously, any significant increase or decrease in income, decrease in income of the person paying support, increase in income to the person receiving it. As a guide, I'd say over 20% change usually is something the courts will consider substantial. Below that's questionable sometimes. Loss of a job after a couple months that you haven't been able to find another job, medical disabilities, and anything else that's going to cause a substantial change in either your substantial decrease in your income or a substantial increase in the other party's income. Okay, so those are the basic reasons to seek a modification. Now, let me just put into a nutshell the steps you should take when trying to actually get that reduction or termination. The first thing I always tell my clients is to first make an analysis of whether it makes sense or not. First, to even seek the modification, and then if it makes sense to use an attorney. And I say that because a lot of people that come in to modify alimony, in part, are a little upset and some even angry that they're still paying alimony to a spouse that they found so disfavorable that they divorced. So they're motivated by that anger and contempt to seek a modification. They may have a very short time left in their term, a small amount of money, and back up until recently where it was tax deductible, the payment wasn't even that great. So a lot of people I'll meet with in those circumstances, I say, it doesn't make sense, at least to the extent of hiring an attorney, because you're going to spend more than you're going to get. So you have to first look at that. If it even makes sense to open a can of worms, you may have children that you're dealing with the other spouse, and there's some value that you're getting from that. But the first step is to see if it financially makes sense to move forward to seek a modification. Second, what I always try to do is first address it in a letter to the other party. Now, in 99% of the cases, the other party is not willing to just agree to reduce their alimony or terminate, especially. But it's the same kind of analysis, and you try to urge the other side to use that analysis, and that is it going to pay them to fight the request to modify if the case is strong enough to suggest you're entitled to it, like in a retirement case. Now, more often than not, they still think it is worth it because it's our initial burden moving into court to show that there's a change of circumstance or a reason under the statute to get a modification or termination. So a lot of people aren't willing to do it, but I do it because the problem is, and most people don't realize this, when you go into litigation, well, let me step into that. So the next start, if the letter doesn't work, you have to file a motion to terminate or modify your alimony. And that motion needs to have many things attached depending on the reason, but at a minimal, it has to have the agreement or court order for the alimony. It has to have the original or last case information, well, it should say actually any case information statement that was filed during the divorce by both parties, and any other financial information that existed then, as well as support for the reason that you need the modification. Now, if you're successful, this is one of the cases where the more successful that you become, the more costly and difficult it becomes. It's almost like a mini divorce, I say to people, because you still, once you do the motion, if you're successful, only says you've shown enough to get a hearing, which means from the motion to the hearing, you're going to go through what's like a mini divorce. You're going to exchange discovery, you're going to do case information statements, you're going to have depositions, you're going to go to early settlement panel and other settlement conferences. You're going to go through almost everything you did for divorce. It's going to take about a year. Now, that's very long and very expensive if you have attorneys in it. So that's why the first two steps are to make the financial analysis of if it makes sense to go forward, at least with an attorney. But you want to try to urge the other side to make the same analysis, because most of the alimony modification applications that are made aren't as effective as they could be if both parties had been a little more reasonable and realized in the beginning the costs that would be associated with doing it. So that's alimony modification in a nutshell. If you have an issue, I urge you strongly to first do a little research, not a lot, because it's hard to know what you're going to get on the internet, which I know I always say that, and it's ironic because I'm always on the internet when I'm saying that, but you have to be careful, and you definitely want to speak to an attorney, even if you're not going to hire one, just to get a sense of if you're moving in the right direction and if it's even worth it for you. I hope this information helps you. If it did, please give the video a like and share it so other people get to see it. You can also subscribe so you get notifications of my videos, and when I go online, I usually try to do it every day in one way or another as much as I can. So tomorrow I'm planning on 4 o'clock, which will be April 5th, 2019. I'm in court in the morning, so it's hard to say if I get back and I can make it, but that's my plan. If there's something you want me to try to address, it's going to be my daily topic, which is shorter. Just send me a message, and I will do my best to address it. With that, I'm going to sign off.